Yes.
But we have come against the Outer Pathways Tribunal, my lord, Central Administrative Tribunal. Here, my lord, the petitioner retired from service on 31st December 23, my lord.
Yes.
Now, my lord, prior to that, his date of increment, my lord, was 1st July, my lord, every year.
You have not filed your written notes of argument. We have asked you, both of you, to file.
I have filed additional lordship
File.
on 4/12.
Any written notes of argument, file.
I have, my lord. I pass it out.
You have also filed.
Additional affidavit lordship.
Now file the additional affidavit and the notes of argument I have asked for.
Written argument lordship I have not filed. I missed it. I filed the additional affidavit only. Otherwise, lordship,
You have gone through the supplementary affidavit.
Yes, my lord.
You want to respond to this?
Well, in my humble service, it will not be necessary, my lord.
Very well. Where is the supplementary affidavit? Is the supplementary affidavit? You file your, both of you file your written notes, and then we take up the matter.
Well,
Very well. Supplementary affidavit filed on behalf of the respondent. Send this file, huh? Just yes. 20. Yes, you have to file a fresh.
Lordship.
My lord, yes, my lord. You have to bring on records to the papers, my lord. The state has to bring on record the paper, my lord, the
What
details, my lord.
What is it? What paper?
what papers?
My lord, with regard to the pay scale, my lord, and with regard to the qualification of the pre-primary teachers, the entire details, my lord, along with primary teachers, my lord.
My lord, we are submitting two written submissions, my lord. Initially, the one that was corrected, And secondly, my lord, we have prepared a comparative chart between the pre-primary and the lower primary teachers, lordship.
Where?
The thicker one, my lord.
No, these both are connected.
Both.
Why you have filed both?
One is corrected, my lord, and with the directions of this honorable court, the differentiation between the pre-primary and the primary, my lord, the second written submission, my lord.
I see.
And this written submission, the second written submission is supported by all documents, lordship. And we have kept it in different colors, lordship, to show that the difference.
Yes, yes. But these were not before the trial court. Before the learned single judge.
No, my lord, this is...
No, these documents were not before the learned single judge.
It was before the learned single
All
judge,
these
my lord.
documents.
My lord, but here we have further documents, my lord, to supplement, because this is not an appeal, my lord. This is a fresh writ, lordship, as of now. So now we have acquired further documents from the department,
You're
lord.
hearing by this channel, so you're hearing. Correct. Have you served them a copy?
Yes, my
I
lord.
just received, my lord.
Just received.
I examine, my lord, the qualifications and the pay scales, my lord.
And it is on my instructions, my lord, that when these teachers were appointed by the district council, they were appointed temporarily, and that appointment stands till date, my lord.
No, but is there any written document in that on that regard?
My lord, when after the state government took over the district council schools, my lord, no fresh appointment letter was given to them. So the appointment remains from the time the district council, the
Have
district
you
council.
said so in your affidavit?
My lord, we have said so in our written submission, my lord.
No, but it has to be on the affidavit. Written submission is
No,
cannot
my
be
lord.
deholds the pleadings.
No, my lord.
My lord. So if
If you want to file an affidavit, file
yes,
it.
my lord, if,
Well,
with the permission of this honorable court, lordship.
The learned counsel on behalf of the respondent number 3 in compliance of the earlier direction.
From supplementary list, number 1.
Choose fine. Oh, yes.
Please, Your Lordship. Your Lordship, the amicus is out of station, Your Lordship.
Please, little bit louder. We can't just hear you.
The amicus is out of station, Your Lordship.
No, very well. Amicus may out session, but I mean one certain.
Lordship, compliance to the order passed on 8. We have filed a small report today. The query that was fallen from the court.
Don't require this is remember. It is about two land. One is from the defense,
Lordship.
one is from the
Lordship. So we have answered both the queries. Lordship, we can have it page 4.
government of Meghalaya Transport Department controls companies in Malacca. The responding is going on record and action taken report on the ministry program. Yes, this is what exactly I was apprehending.
Absolutely. In fact, we're
The
grateful.
affidavit is giving an impression it has already been handed over.
Lordship, that's why I submitted the other. We were grateful, Lordship, because that was slightly vague. No, we have been very specific now. By 31st January, at least 11.75, Lordship, we have addressed it, and even the other land, 10.3. That's at 2B.
On 17th April, Ministry of Defense party at once with the permission. So how soon you can process it and give the fund to the office of the Deputy Commissioner, Revoy, to facilitate the purchase?
No, my lord, there are some issues, my lord, from the defense perspective, my lord. But here, what I
Give us just 1 minute. So the probability of completion. These. No, probability of completion of the airport. 3.
No, well, that's a probable date of removal of because certain hills have to be chopped and certain trees have to be felled, my lord. That is the probable date
So
of.
that is 30th September 2026. Then even in 2027, the airport would not come up.
Because now, my lord, we have filed affidavit on the previous day, my lord.
Give us affidavit. But why it was not being expedited earlier, huh? Give the affidavit. Why the timeline cannot be shortened? Yes, the affidavit filed by the. You have filed an affidavit, Dr. Mosiko?
My lord, on day before yesterday you filed, my lord, on the
Where is that?
previous date of hearing, my lord, on 5th of December.
Then even in 2027 will not come up. If this is the timeline, then in 2027 also it will not come up.
But we are looking most probably at 27 end, my lord, if everything goes smoothly.
No. Construction, see that you have to float the tender, so the work will not start before 2028.
My lord, construction work can because here what happened, my lord?
Not 2027, I'm sorry. Not before 2027, not 2027.
Yes, ma'am. My lord, as far as we are concerned, my lord, there are 3 issues, my lord. Now, one is construction, my lord. Now we have issued the tender.
Now, you have issued the tender.
L1 bidder was found to have submitted some forged documents, my lord. So the tender process has to be cancelled and we have refloated the tender, my lord.
No, but how can you float it? See, the difficulty is this. You float a tender without having all the clearances. So suppose the tenderer will not exactly know what would be, because you do not know how much land will be ultimately you get. It is all on paper. On what basis? On what basis the tender would submit is?
We are proceeding on the basis of assurance given by the state, my lord, that 10.3 acres of defense land, which we know
But
which is the
can
land.
there be a tender on the basis of an assurance? It has to be that the entire thing should be in black and white.
And ideally, everything should be in our position.
So why you have issued a tender without having these things finalized? That will be a wasteful expenditure. That will be completely a wasteful expenditure.
In a way, the lordship is right, my lord, on that.
Yes. Why this exercise is undertaken when the ground is not ready?
Yes.
You have to recall the tender. How you have made a tender?
Because land, otherwise we know, my lord, which is we have demarcated the area. This is the defense land we require, and this is the land, private land.
You are representing AI.
My lord.
Now AI can only tender provided the AI today, even today,
My lord.
you say that the defense issues have not been fully sorted out.
My lord.
Now, the learned additional report general has said that before 26 September, nothing is going to happen. Probable dates.
No, my lord, that is the because what happened, my lord, there's a runway, my lord. Now there's a flight path, my lord. How the flights will land and how it will take off, my lord. So there are certain hills, my lord, at a distance of 3 kilometers, 4 kilometers.
So, unless the topography is known to the tenderer, there will be a physical inspection before a tender is called for. The tenderer, I think there must be a clause in your tender document that he will have a right to have a physical inspection of the topography, or then he will submit.
But tender is only for runway, my lord, not for removal of the obstacles, my lord.
No, for the runway event,
yes,
unless he sees the topography
of the land where runway is to be constructed, my lord.
Yes.
But that we are proceeding on the basis of land that has been offered to us, my lord. Though not handed over physically, my lord, we are proceeding on the basis that we'll get this land and we'll get this land, my lord. Just to cut short the time. Otherwise, if we float tender after getting the position of the land, my lord, that may delay it further.
You have received the offers.
Yes, my lord. Technical bits are being examined, my lord, now. We have stated it is 3 of them.
So all of them have been given physical inspection of the proposed construction.
Yes, ma'am.
They have taken physical inspection.
Yes.
But the quantum of land has not yet been properly identified, or it is on expectation.
It is on the basis of expectation.
So if on the basis of an expectation, can there be a tender on the basis of an expectation? The terms, everything should be specific and precise.
Because it appears we proceeded only on the basis, my lord, that state government said that this land from here to here will be handed over to the airport authority.
But this is also part of it, no? Come to about 22 acres. Approximately 22 acres.
Yes, ma'am.
So out of this 10.3, so far 7.7 was agreed upon. The remaining portion of defense is still under negotiation. That is what the state government has given a report.
From defense, I have the communication, madam. I have placed it. It is not an affidavit. I placed it.
Sorry. 17.
So, my lord, 10.3 acres of land. This is a grant of working permission to government of Meghalaya, my lord. 10.3 acres of land, defense is agreed to hand over to state government, my lord, on the condition of equal value of land will be given by the state government to the defense authorities, my lord. So, my lord, the issue that has come from the perspective of defense authorities, my lord, your lordship, kindly see this chart, my lord. There's a table. The land value has been provided at the rate of 241 rupees per square feet, my lord. Your lordship has seen that. And your lordship kindly turns to the last page of this comparison, my lord.
Yes, yes.
Now this is a letter from Deputy Commissioner, my lord. They are valuing the land at 150 rupees per square feet, my lord. So, my lord, what I'm praying, if a direction can be issued to the Deputy Commissioner, my lord, to convene a meeting between local military authorities and Defence State Officer and sort out this issue, my lord. Because the valuation given by Ministry of Defence is 241 rupees per square foot. State is saying is 150 rupees per square foot.
But who is to decide this?
But if they can sit together or work it out, my lord. If the
Now,
DC,
who will sit together?
Deputy Commissioner, my lord, who has issued this letter,
Deputy Commissioner and
Joint Secretary, my lord, Transport Department,
Deputy Commissioner
Joint Secretary, Transport Department, my lord, and local military authority.
and local?
Local military authority, Station Commander Umbral. Because otherwise we are ready to hand over the land, my lord. But this valuation has to be sorted out by the state.
Ready to hand over, the defense is ready to hand over.
Defense land.
So that is why, so long this monetary aspect is not concluded,
Yes, ma'am.
the defense is not handing over the land.
Yes, ma'am.
But why don't you hand over the land for the time being? It's a public project. So, and this will be worked out later in between, because some they have agreed upon. It's a public project after all.
My lord, we have otherwise no issue, my lord. Because otherwise also the private land also state is yet to hand over, my lord. They're asking for timeline to 31st January. The other 11 acres of land, my lord. If they can sort out within this period, my lord, otherwise we have no problem in handing over the land.
Exactly. Mr. Khan, you are taking too long a time. It cannot be. You have to conclude this by December. Direct purchase of 11.75 acres.
Actually, we'll make an endeavor.
Huh? Try to
December,
make it by 31st December.
the only problem, Lordship, is this. Not problem exactly, but after 21st, we have the
Sorry?
Christmas season. It goes on for at least 10 to 11 days. And then winter also has its own toll on the.
Then you do entire complete by first week of January,
Lordship,
by 7th of January.
we'll communicate, Your Lordship. We'll make an endeavor.
Take down. Action taken report on behalf of the state government and Yes. Yes.
May I please, your lordships? Am I audible, lordships?
Oh, this is the settlement matter.
Yes, ma'am.
Yes, lordships. Yes, lordships. Am I audible, lordships?
Yes, yes, yes. You
I'm
are
sorry,
My
saying-
lord,
I'm not being able to physically be present, lordships.
Where's the notifications?
The respondent has filed the agreement. Would lordships kindly come to page 8? The agreement starts page 6. The agreement is okay. A little bit of tweaking and ironing of some phrases need to be done by the court. So we request that that may be done.
Sorry?
The agreement between the parties have been signed, and
So we
in terms of,
dispose of this matter as.
yes, but
in terms of
lordships,
settlement, my lord. In terms of settlement, my lord.
may I just, what I'm requesting the High Court, the Lordship's bench is a little bit of ironing out of certain creases need to be done. So I'll just point it out, and Lordship's may in its wisdom tweak it to
No,
that extent.
we'll not touch anything. We'll not touch anything. Is as it is.
No, because why I'm telling Lordship, let me just demonstrate two clauses are mutually inconsistent.
No, then you have see your client has signed it.
Yeah,
And
that is
also-
my difficulty. That is my difficulty.
So
But
you
therefore, I
cannot
thought
improve. So we cannot do it. We cannot touch upon this. We cannot by
No,
your
no.
order modify this.
if my friend agrees, he will also agree it is mutually. If you just point out,
No,
he
my
will
lord.
also
The appeal can be disposed of in terms of settlement, my lord. In terms of settlement, my lord.
Yes, exactly. We are not going to touch anything on this.
Yes, my lord. And the
Take down.
all petitions will stand disposed
down.
of in the light of the
This is an
settlement.
application for recording.
All I'm saying, if I may just, my learned friend will
We are
also
not
agree there's a
going to. We are
mutual
not going to add a single word in the settlement. That's fine. Take down.
So,
The
very well, Lordship.
application has
At
been
least,
filed
to
for.
that extent that the interest portion will be negotiated, Lordship.
No,
Because
nothing.
no, that
Nothing.
is there already in the clause.
Whatever is there is there. Take down. There's an
Very well, Lordships. Grateful, Lordships.
Thank you.
Grateful.
What is this? What is this matter?
My lord, this is the case, my lord. I am entering appearance, your lordship, for the sole respondent writ petition. They have filed this appeal along with the application for condonation of delay.
Where's the application of condonation? Is there? There is no office report.
Yes,
This is
my
for
lord.
the appellant. You are for the appellant.
Yes, my lord. My lord, if I pray for some indulgence, lordship, if this matter can be taken up in after vacations, lordship, the conducting counsel is on legs before the Honorable Supreme Court, lordship.
Sorry?
The conducting counsel is on legs before the Honorable Supreme Court,
No,
lordship.
we allow the condonation and then we direct. We allow the condonation. 36 days delay.
On the condonation, I will not object, your lordship.
Yes, 36
But
days delay condone. Very
only
well.
thing, my lord,
Condone it. And since no appeal opposition is called for, the allegations are due. Let a letter be there. I have to sign or place all the orders by 1:30. Yes, yes. For the list.
Item number 1.
You also go and type in case I require your recording. All the orders has to be typed. Yes. Is it being listed for the first time?
But the matter could not be taken up, my lord, because mediation was going on in between.
Oh, the mediation failed.
My lord.
So for the first time, I'm taking up this matter.
My lord.
Any previous bench heard this matter? No.
No, my lord.
So this was never heard at all.
No, my lord. Just.
So what basically I do is this: I direct the parties to file their written notes of argument.
My lord.
So just give us an idea what is the matter all about.
My lord, what had happened is that the petitioner before your lordship had filed an ejectment suit and recovery of possession, as well as recovery
of filed a suit for eviction.
Eviction, as well as recovery and for recovery of rent, my lord. My lord, the respondent before your lordship had taken a loan from
You have filed a suit for eviction on the ground of?
The ground of the land has already been sold. The entire suit premises has been sold to me, my lord, by the respondent, my lord.
By the respondent, very well. Sold to you?
Yes, my lord.
Yes, then?
Then, my lord, she is staying. The respondent is staying in the premises, my lord, the suit land, but nor she is away. She is moving out from the suit premises, nor is she paying any rent to the petitioner, my lord. So we had filed a miscellaneous application before the District Council Court, along with the suit, for a direction that the respondent should pay the rent before the court, my lord. So that has been rejected. That's the entire matter, my lord, before your lordship.
No, you are appearing, madam.
Yes, lordship.
Is there an agreement for sale?
Lordship, there was an agreement for sale. There was an agreement for sale first, lordship, and wherein there was a stipulated period of 6 months to clear the loan amount. But surprisingly, lordship, and within just a period of 1 month, the appellant had come up saying that the respondent was I was not able to pay, and so we come to us. We register a sale date. Now, lordship, what has happened is I was like at that point of time in dire need of the. I was in a dire need of the assistance, lordship. So, taking an undue advantage of my position, lordship, and that was on the behest of the appellant, lordship, saying that the moment you pay me back, I will cancel this, I'll revoke this again, the sale deed. So on that situation, lordship, I agreed. I said, okay, because right now I cannot pay you right now. I'll be giving you after that, lordship. What has happened is I have said that there was an issuance of in the meantime, lordship, there was a formal communication. Nothing was said to me, nothing was done. He understood that within 6 months, I am to give you back the 60 along with the rate of interest. And the rate of interest was quite excessive at that point of time. So my prayer was, at that point of time, my humble request to him was, at least give me some time only for the payment of the interest, because the interest is excessive. Now here, lordship, what they have, their rate of interest according to them is 72% per annum. Now, lordship, I was not able to pay that much. Now, for 1 month only, lordship, the interest came around
So they filed a suit for eviction.
Yes, lordship.
So in that, what was the order passed by the trial court?
Lordship, after the...
Which order is under challenge?
My lord, the challenge before your lordship is that the trial court, both the learned court below as well as the lower court, appellate court below, has rejected my application, my miscase, whereby I have sought for deposit of the rent before the court, my lord, or the premises which
deposit of rent would mean that there has to be a relationship of landlord and tenant.
My lord.
But you can ask for, if you say that your suit is for eviction.
My lord. And recovery of rent also.
And recovery of rent.
Also.
Then you treat him as a tenant.
My lord, as of now, because a sale deed has already been executed in my favor, my lord. That also registered sale deed, my lord.
No, no. If the sale deed is there,
My lord.
then you cannot ask any rent from him. How can you ask a rent from him?
They are occupying.
Then you can ask for that if they are so long they're in possession, there will be an assessment of occupational charges. That's all. Nothing more than that. So there is no relationship of landlord and tenant. But if you say that you are asking for payment of rent, then it presupposes there's a relationship of landlord and tenant, which relationship she is denying.
My lord.
So madam, that if you are in occupation of the land, you have to pay some amount.
Lordship, I may just state here, Lordship. Lordship, even before the trial court, the first court, Lordship, we had come forward, Lordship. We had said that we will be able to pay the payment of the principal amount, Lordship. I even brought the money before the court. Also, I said I am going the first principal amount I'll be paying you, but at least give me another just 2-3 months some time to pay the interest and the interest.
Have you challenged the sale deed?
Sale deed.
No,
Yes,
not
Lordship.
in the
I
written
said,
not challenged, my lord.
no, in the written statement, I had categorically stated that, Lordship, in the written statement also, in my written statement also, Lordship, I had stated that in your sale deed, there is no whisper of the agreement for sale. I had stated that, Lordship. And
You have not challenged for cancellation of the sale deed.
cancellation because it had already filed, Lordship, and then in the court, I had just submitted only that what was the fact, Lordship. So I had not
You have
challenged.
not challenged. You have
No,
not
no, Lordship.
Yes. So the sale deed is staring at your face.
My lord.
Sale deed is staring at your face.
Yes, Lordship.
So if there is a sale deed executed in his favor, and then you are no more the owner of the land. If you are no more the owner of the land, then on that basis strength you cannot continue to be in occupation because you have not challenged the sale deed.
Lordship.
But if you are in occupation, and if you are, then they ask for. In fact, they have sought for of your eviction. But so long you are not being evicted, you have to pay the reasonable whatever the occupation charge.
Lordship,
Not
I may
only
just
that,
be, I may just be allowed, Lordship, just a little. Lordship, before that also, before the mediation also, Lordship, before it had come even to filing in before the courts, Lordship, there was a legal notice had been issued to me. On that, Lordship, I had stated, I had even met the person, Lordship, the appellant, and I had requested him that this, at least take the 60, this is what is the principal amount, and just give me little time. Because here, Lordship, you will see what has been taken under the, taking advantage of me. Like I said, Lordship, the earlier agreement to sale, which had happened, the agreement for sale, it had happened on 23/8/2021. Then, Lordship, then a sale deed is executed in 21/9/2021. Lordship, the agreement was very clear, saying giving me a period of 6 months. Now, Lordship, the appellant at that point of time said that this will be as a mode of security, so we will register. But he gave me the assurance that the moment you pay me the amount, I will be revoking this. I'll be cancelling this sale deed. So taking on the assurance on that, Lordship, may I take to page 44, Lordship? Lordship, I am a single mother and I have my children. I have an old mother to take care of, and I am also I'm investing in small time. I'm doing a small time business wherever I can. I'm trying to survive, Lordship. And at this point of time, I was on dire need of the financial assistance, Lordship. That's why I had to approach the appellant. And that also, Lordship, even after that also, Lordship, I had tried my best to settle the matter by saying that I'll be giving the principal amount, just a little request of giving me a little time. And I had said that I would be paying 20 lakhs extra, but what you are saying is an excessive rate, Lordship. And that was not taken into consideration. And time and again, Lordship, after that also, even in the court, before the court also, the settlement was tried from the first court below, learned court below, Lordship. And at that point of time also, I had stated before the court that I am ready to pay the principal amount. Even now also, I'm ready to pay. But then the appellant, he refused to take that, Lordship. Now, I was never like, I had never given my right title and interest over the over the suit property, Lordship. And in fact, Lordship, even the appellant at that point of time also, she should have, if the sale deed is there, then he should have come under the title suit, Lordship. And for that, Lordship, we had even filed a counter claim also, Lordship, before the court, before the
That's time
Honorable
barred.
First Court.
That's only time.
That
barred.
was not time barred at that point of
But
time,
what
Lordship.
happens that after this, the plaint was filed, they have filed a written statement.
No, in the written statement, they have made a counter claim.
No, they have not filed. They have not made any counterclaim in the written statement, my lord.
Lordship.
But they have said that they have filed a written.
Subsequently, my lord.
No,
Subsequently.
maybe. So the issue is this: whether there has been. So in the counter claim, they must have challenged the sale deed.
Yes, Lordship.
They must have challenged the sale deed.
My lord.
Yes.
But subsequently, my lord.
So ultimately, if you succeed, then they will get a mean profits.
My lord, what had happened is that because the counterclaim was filed after the period when the written statement has already been filed, then the court has already fixed for issues and documents. After that period, they have filed that.
Very well. If the court has accepted the counter claim.
No, my lord, we have not. We are yet to file our objection to it, my lord.
Very well. Very well. That has to be seen. So they have made a counter claim.
My lord.
The counter claim is there. So if the counter claim is rejected for some reason,
My lord.
then the court may decide, because what they are saying is this: there are cases that the sale deed was executed under quash, undue influence. She was in dire need of money, so she succumbed to. Initially, there was an agreement, so this land was given as a security.
No, my lord. When she said that she will not be in a position to repay the loan, that's why she had executed.
No, that's yes. So she said that this land was basically a security. It was a kind of a mortgage by conditional sale.
Yes, Lordship.
It's a case of mortgage by conditional sale.
Not exactly, my lord. There's a clear-cut sale deed, my lord.
No, that is when the loan agreement was there.
My lord.
Then there must be a reference that this property would remain as a security.
No, there's nothing of that sort, my lord, in the loan.
But the understanding was that this property. What is the loan agreement? What is the loan agreement?
If your lordship comes to page 37, my lord.
Page 44, Lordship, the translated copy.
Page 40?
44, my lord.
Page 44.
44, my lord.
Page 44.
Lordship, paragraph 2.
Yes. And had mortgage security as a symbol. Paragraph 2.
No,
Yes,
my lord, this is with regard to the pata which was issued to her, my lord, not the sale deed.
This precedes the sale deed.
Your lordship.
Lay down. Lay down.
My lord, there are tenants. There are 5 tenants.
Call.
There are 5 tenants in the